Hello and welcome back to the Neutral Voice. I'm your host, Samung Deb Barma. This podcast series explores neutrality as a professional discipline and examines how experienced neutral professionals help individuals, businesses, and institutions navigate complexity, disagreement, and decision making. Today's conversation explores an important question. Disputes are often approached through legal arguments and procedural rules, yet meaningful resolution depends just as much on understanding the people behind them. How do language, culture, and careful listening influence the way experienced neutrals understand conflict? I am delighted to be joined by Ms. Malgorzata Judkiewicz-Garvan, an international arbitrator, lawyer, and university lecturer admitted to practice in both Poland and Peru. Alongside her work in commercial investment and public procurement arbitration, she also holds a background in translation and interpretation, an experience that offers a unique perspective on communication, understanding, and neutrality across different legal and cultural settings. Ms. Malgorzata, thank you very much for joining us today.
Thank you, Samung, for your presentation. Thank you for the invitation to the program. It's a pleasure to be here.
It's a pleasure to have you here. So I'd like to begin with something that immediately stood out to me while reading about your professional journey. Before becoming deeply involved in arbitration, you studied translation and interpretation, a discipline that's fundamentally about understanding meaning rather than simply words. People often think that understanding begins with hearing the words being spoken. Yet in disputes, what people mean and what others understand are not always the same. Has your background in translation and interpretation influenced the way you listen to people in conflict today?
Yes, very much. So as you said, my first academic training was in translation and interpreting applied linguistics more generally. So it included not only learning languages, but also learning about languages and communication. I learned about psycho and social linguistics, about discourse analysis, pragmatics. So that shaped me before I entered the legal practice. So translation, for example, teaches you humility because you understand very early on that translating word for word is not enough. So you need to understand the context. It is very easy to see that a translation made word for word sometimes may not make sense in the target language. So you need this context because each word may carry different legal, different cultural, or different emotional meaning, depending on context. So in disputes, I think this is especially important because parties often believe that they have been perfectly clear and understood, while the other side might have understood something quite different. And there is this concept in linguistics, which is called common ground, which is the background that people communicating assume as shared between them, the shared assumptions. So in simple terms, it's what both sides assume that they can take for granted when communicating. And in disputes, I think that is very relevant that this common ground is often fragile because parties may use the same words, but may have different assumptions behind them. So when I listen to parties, or when I listen to as arbitrator, or when I listen to the counterparty as counsel, I always try to ask myself, what is this person really saying, what they are assuming? And I find it useful to always ask questions to make some rephrasing or summarizing of a point, just to make sure that I understood correctly. And I would say that listening is not passive at all. It is rather an effort to understand meaning, context, and these assumptions.
Thank you. Moving on, in disputes, people, even though they're involved in the same dispute, often leave a conversation believing they've been perfectly clear, while holding very different understandings of what has actually been said. Over the years, what has your experience taught you about recognizing what lies beneath the words before reaching a decision?
One important lesson that I've learned is that understanding must come before evaluation. So in arbitration, we often move quickly. We just want to decide who breached, who is liable, who has to pay how much. But before deciding, the tribunal needs to understand not only words used by the parties, but also those assumptions that I've already mentioned behind their positions. So sometimes the real issue is not the rule itself, it's the factual commercial premise that is held behind the parties' arguments. So very often the parties are not even disputing something, disputing the existence of a fact, for example. They may both rely on the same fact, but give it a completely different meaning. So one party may say that this fact proves bad faith, while for the other party, the same fact just proves ordinary commercial conduct. And the same may happen with legal rules. They may be invoked, the same rule may be invoked, but interpreted differently by different parties. So this, I think, has to do with different assumptions, different interests, different legal background. And of course, sometimes this may be strategic because the party might want to maybe not manipulate, but trying to frame the facts or the law in the most favorable way. But sometimes I think it is genuine. People may honestly believe different things starting from the same fact or same rule or same document. So I think that for the arbitrator, the task is to identify this gap before deciding. So is it the disagreement about what happened or about the consequences of it or about some kind of assumption behind the fact mentioned? So understanding doesn't mean believing, doesn't mean agreeing, but the arbitrator has to understand both sides. It doesn't mean that they will agree with both of them, but it means to be disciplined enough not to judge or not to decide based on a misunderstanding. So a good decision requires this clear bridge between the proven facts, the applicable law, and the conclusion reached. So I would say that active and careful listening is not just the human quality that we all should strive to have, but it is part of decision making, good decision making, and of the procedural fairness.
That's a very holistic approach and perspective that you have given. Now, from your experience, sometimes the most significant progress in a dispute comes not from a legal argument, but from a moment of genuine understanding. Without referring to any confidential details, is there an experience from your practice that illustrates how listening differently changed the course of a dispute? And what did that teach you?
Yes, without referring to any confidential details, I worked on a case involving a substantial claim for loss of profits. And the allegation was that my client had damaged the reputation of a product, of a food product, and made it impossible for the brand to continue being a success. So one of the assumptions of the expert report was for the economic expert report was the fact that the product could generate substantial sales through bodegas. Now, bodega is a Spanish word meaning different things in different Spanish-speaking countries. It may be a place where you produce and store wine. It may be a warehouse, or it may be just a store. So the issue was not that the word was incomprehensible because the expert coming from another Spanish-speaking country could understand that here in Peru, bodega is a store. But the issue was that its local commercial meaning was not taken into consideration. So in Peru, a bodega is a small neighborhood store associated with everyday products and relatively accessible prices. The product in question, however, was a premium product. So the real question was not if it could physically be sold in bodegas, because it could. The real question was whether that was a realistic sales channel for this type of premium product and whether the projected sales reflected the actual situation. So by unpacking the local meaning of those words, we were able to challenge one of the central points, central assumptions of the damages analysis. And it was not about the semantics on its own. It was about whether the commercial model reflected the real market. So that experience stayed with me because it showed how language, culture, and evidence can meet in arbitration. So sometimes a single word carries an entire commercial assumption, and if that assumption is wrong, the legal and economic consequences of this analysis may change significantly.
Thank you. That's a very interesting narrative that you have given. I working across different legal systems and cultural environments remind us that people don't just speak different languages; they can also express disagreement, trust, and fairness in very different ways. Have those? How have those experiences influenced your understanding of what it truly means to be neutral?
Working across cultures has made me more cautious about my own assumptions. And neutrality is not cultural blindness. It's not saying that I treat everyone the same because there is no differences. Real neutrality, in my opinion, requires to be aware that people may express disagreements, trust, urgency, or whatever other feeling in different ways. So, for example, in some cultures, direct disagreement is normal and even expected. In other cultures, it might be offensive or even aggressive. The same goes for rejection. So in my experience, for example, in Peru, people often find it difficult to say no directly. They may prefer to avoid open confrontation or soften the message. So for me, coming from Poland originally, where communication can be more direct, this was initially challenging to adapt and first to understand this and then adapt my own style to the communication style of the place that has become my home. Another example that comes to my mind is small talk. In many cultures, you have this small talk at the beginning of a meeting. In Poland, we tend to perceive, or at least I used to perceive it as waste of time. They want to go straight to the point. So these are those differences that you have to be aware of because they don't mean you can't treat everyone the same. And it is also important in international disputes. Party may interpret silence as respect, while for another one, it might be a sign of evasiveness. Direct criticism may be perceived as normal advocacy, while for somebody else, it may seem aggressive. Delay, it might be treated as ordinary conduct, ordinary coordination, internal coordination, while for the other party, it means lack of interest or bad faith. So I think a neutral should not immediately turn those differences into conclusions about credibility or good faith. There is also research in linguistics, again, in pragmatics, showing that misunderstandings often arise not because people don't know words, but because they attach different assumptions to the same words, to silences, to the behavior. So I think this is very relevant to international disputes. For me, neutrality is not absence of perspective. Of course, every arbitrator has a background, has training, experience, comes from certain legal culture and generally from a culture. And the same applies to parties and their counsel. So as arbitrators, I think we must be very careful not to allow our own cultural background experience to distort the way we perceive others and the conduct that may initially seem unusual or inappropriate or maybe even sometimes shocking. So neutrality is the discipline of controlling ourselves and controlling our own assumptions and deciding strictly on the basis of the evidence, the record, and the law.
Thank you. That's quite a comprehensive manner in which you have described. I think I'm quite struck by what you mentioned about assumption and the assumptions that we have been challenged in through these circumstances. That's been very interesting. I also like to know further from you, from your experience, that some disputes stay with us long after they have concluded because they leave us with lessons that continue to shape our professional judgment. Looking back, is there a particular experience that has influenced the way you now approach listening, understanding, or neutrality?
So one lesson that has shaped me does not come from my own personal experience in a specific case, but more broadly from a trend in Peru of the annulment of arbitral awards due to defects or insufficiencies in the reasoning of an award. So in Peru, this is a very sensitive issue. Of course, annulment is not an appeal on the merits. It is the Peruvian arbitration law follows the ancestral model law, so there's no doubt about that. In theory, courts should not even assess the tribunal's reasoning, but at the same time, the tribunal's award must be very well reasoned and must show a clear understanding of the dispute and the clear path between the parties' arguments, the evidence, the applicable rule, and the conclusion. So in practice, what Peruvian courts will do, they often will review whether the reasoning of the award is sufficient, coherent, and not merely apparent. So this creates a delicate balance because the court should not review the correctness of the decision, but it may examine whether the award contains genuine reasoning capable of supporting the decision. So in other words, the judge will analyze how profound the arbitrator's analysis is, the reasoning. So there is in my opinion, a significant percentage of annulled awards, because it is around 20% of awards that go for annulment, they get annulled for reasons of some defects in reasoning. And that has made me much more aware of this issue and much more cautious when drafting and deciding, because now that I am working and sitting as arbitrator, I have to be very cautious about it. And it's not enough for an arbitrator to know internally why they are deciding in a certain way. This must be showed in the word. The reasoning must be visible. Parties have to be able to see whether their arguments were considered, why they were rejected, and so on. So for me, this is directly connected to listening. So a well-reasoned award is not only a legal document, it is also evidence that the tribunal listened properly, and you can see it very clearly when the award summarizes parties' position. You can already see whether the tribunal truly understood the case or whether it's misunderstood something, oversimplified, or simply lacked knowledge to decide it. But a moment came that it had to be decided, and the reasoning is not so complete, we would say. So I think drafting is also part of listening, part of this duty to listen that arbitrators have, and the award should identify the real issues, reflect the parties' positions accurately, assess the relevant evidence, and then explain the decision in a logical and coherent way. So I would say that this lesson has stayed with me, and listening doesn't end at the hearing. It continues to the award, and the award must reflect the understanding that the tribunal must reach.
Thank you. Appreciate the honesty and the clarity with which you brought your personal experience. It's very enriching. Now, as we look ahead into the future, as disputes become increasingly international and more culturally diverse, technical expertise will always remain important. Do you think qualities such as listening, cultural awareness, and empathy will become even more valuable for the next generation of arbitrators and ministers?
Yes, I do. I think, but I would not describe it as alternatives to technical expertise. I would describe it as complementary. So I think that the next generation of arbitrators, arbitrations of the future, will still need to understand the law, the procedure, of course, the evidence, the due process. But disputes are increasingly multilingual, multicultural, multiculturally complex. So I think this means that the arbitrators will also need to manage different communication styles, to understand those differences, understand different legal cultures, and understand this sometimes very deep mistrust between the parties. And I think this will become even more important with technology, because AI may help process language and information, and it may do it very efficiently, but it might not always be neutral simply because this is technological. We know already that language technologies may reproduce or even amplify the linguistic and cultural biases. I've come across some research showing that language models can make different judgments made on different dialects of people speaking, so there can be bias. So the answer, of course, is not AI is biased, so humans are better, because humans also can be biased. I would just say that arbitrators have to be very careful, because they bring their own background, their own assumptions, legal culture, and those unconscious reactions to the process. So for me, the real point is whether we need to be more cautious when when we make the judgment, and the judgment, I think if it stays human, it will be more beneficial to the parties, because I would say that human beings are more aware than technology, that language or tone or silence can be misread. So I think this is where the human aspect will stay with the relevance. So I think listening and cultural awareness will matter even more. And a good neutral must understand not only what is said, but what is behind the words, what may be assumed or what the parties assumed, what might be distorted in the process, and the distortions may come from a person, from technology, or from translation. So we just have to be aware of it.
Thank you. Those are really valuable lessons. I think all the aspiring lawyers and professionals who are looking forward to go into this domain of practice. So thank you. Now, as we draw towards concluding our conversation, I'd like to end on a personal reflection. Your career has involved helping people communicate across languages, cultures, and disputes. Has that journey changed the way you approach listening or difficult conversations in your own life?
I would say yes, definitely, because working across languages and cultures makes you more aware of those differences and of the fact that many difficult conversations sometimes fail, not because of words, but not because someone doesn't have anything valid to say, but because of the assumptions made by each person communicating. So it has taught me to resist the temptation to jump quickly to conclusions. And I think in both professional and personal conversations, clarity is important, but real clarity many times requires slowing down, asking questions, checking whether I have understood correctly. So sometimes you have to also look for a deeper meaning, deeper reason, not always visible at the first occasion. So I would not say I always succeed in my personal life, of course, but I think this journey has definitely made me more aware of these circumstances and of the fact that listening is not just waiting for the other party to stop speaking and for your turn to speak. It is trying to genuinely build a bridge and understand what the other person wants to transmit.
Thank you very much, Ms. Malgorzata, once again for joining us and for sharing your thoughtful reflections and experiences. We look forward to continuing such conversations in this podcast series. To all our listeners, thank you for joining us. This has been The Neutral Voice.
Thank you very much, Samung, for having me here. And your questions really made me reflect about this issue. And it was a very enjoyable moment. Thank you.